This is the lecture on the historical overview of legal issues in special education. My name is Dr. George Giuliani from Hofstra University, and today we're going to really talk about the history of special education and talk about the legal issues surrounding the history. And it'll be from Brown versus Board of Ed up to our current law on special education, IDEIA. Now, the first thing to understand about special education is that over the years, special education has been restructured and transformed by legislation. I want to be very clear about this. The reason why we have what we have in special education today is because the law dictates it. The law mandates it. And without the law protecting children with disabilities, we'd have very few assurances that things would get done the way they're supposed to be done. So as you'll see, over the years, we have developed a very strong special education law. But so much of special education comes from where the law tells us it needs to be. Now, if we go back in time a little bit, Jack, to 1948, one of the things that you have to understand is that only 12% of all children with disabilities receive some form of special education. That also tells you that 88% of kids with disabilities were getting no special education whatsoever. There was nothing really to protect these children and no laws to say that special education had to be mandated within the schools. And by the early 1950s, there were some special education services and programs available in school districts, but very often undesirable results would occur. For example, students in special classes were often considered to be unable to perform academic tasks. We didn't think of children with disabilities to be ones who would really be the academicians of the country, and consequently, we didn't invest a lot of time and energy into their education. So students with disabilities would often go to special schools or classes that focused on learning manual skills such as weaving and bead stringing. And although there were some programs that might have existed for kids with special needs, it was very clear that discrimination was as strong as ever for those with disabilities in schools. But in 1954, legislation and court cases to prevent discrimination in education first came to notice with the famous case Brown versus the Board of Education of Topeka, Kansas. Now, Brown versus the Board of Education of Topeka, Kansas is a case that I'm assuming you have heard of before. It is without a doubt the most popular and most famous case in the field of education. One of the ways to think about this is that if you ask people, name one court case in education, many people could tell you Brown versus Board of Education. And if you say to them, well, name another one, most of them probably couldn't name one other case. And that tells you how important and how significant Brown versus Board of Education is. Now, there's one other thing to note about Brown versus the Board of Education. This case had absolutely nothing to do with special education. This was not a special education case in any way, shape, or form. And yet, it was going to play a very significant and important role in the formation of children, of the needs being met of children with special needs and the rights of their parents and children as well. Now, to understand Brown versus Board of Education, you have to know what happened prior to Brown. And for much of the years preceding the Brown case, race relations in the United States have been dominated by racial segregation. And this policy had been endorsed in a Supreme Court case in 1896 known as Plessy versus Ferguson. And you might have heard of this case, Plessy versus Ferguson, back in your social studies classes. But in Plessy versus Ferguson, the Supreme Court held that as long as separate facilities for separate races were equal, the segregation did not violate the 14th Amendment of the U.S. Constitution. No state shall deny to any person the equal protection of the laws. In a sense, you could have separate but equal facilities. And that case, Plessy versus Ferguson, and what came down on Plessy versus Ferguson is how this country ran so many things over the course of the years. And in schools, what we had separate educational facilities for white children and separate educational facilities for black children, and that's how they were referred to at that time, the whites versus the black schools. So when the case came to the U.S. Supreme Court regarding segregation in schooling, Chief Justice Earl Warren read the decision of a unanimous Supreme Court, and this is what he said. He said, "We come then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities?" Does this segregation, in a sense, constitute, for the minority group, does it deprive these children equal educational opportunities? And Chief Justice Earl Warren says, "We believe that it does." They go on to note, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal, and therefore we hold that the plaintiffs, Brown here, and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of equal protection of the laws guaranteed by the 14th Amendment." Okay, so in Brown versus Board of Ed, the U.S. Supreme Court comes down with a unanimous decision that these children, the black children, were deprived of equal protection under the laws, under the 14th Amendment. So the Supreme Court strikes down the separate but equal doctrine of Plessy for public education and ruled in favor of the plaintiffs and required desegregation of schools across America. The court stated in Brown that segregation based on unalterable characteristics, with the result being inequitable opportunities, could not be upheld in the United States, and demanded that such segregation end with all deliberate speed. So again, in Brown, the segregation was based on an unalterable characteristic, race. Okay, race is not alterable. And they said, when you segregate based on an unalterable characteristic, and there is inequitable opportunities, that segregation is unconstitutional, and it must end with all deliberate speed. And we will stop here and move to part 2 of our lecture on the history of special education.